Hello, everybody, and welcome. We'll give it just a minute so that everybody can get kind of settled in. Hopefully you have something good to eat or munch on while we're here for the next 90 minutes. We were just talking to Jerry, and he said you all are having beautiful spring-like weather like we are up here in Sacramento.
It's nice. Came on right on time for the 4-day weekend, or 3-day weekend, I should say. 4 for us.
Yeah, right.
Timing is everything, right?
Good for businesses.
Absolutely. Get some people out and about and visiting some places.
Yeah.
Okay, let's go ahead and start. So again, good afternoon, everybody, and welcome to the Employee Handbook webinar that is sponsored by our friends at the Monterey County Workforce Development Board. Welcome to everyone. We're thrilled you're here. My name is Tara Brennan, and I'm the events manager here at CEA. And before we start, I just want to go over a couple of details with you about the webinar. Your audio will be muted. So if you would like to talk to us, we would love to talk to you back. Please put any questions pertaining to the presentation into the Q&A box that's going to be located down at the bottom of your screen. That's where our presenters will be monitoring, and they'll be able to help you out with any of the questions that you have. If you have any technical difficulties, or if for whatever reason you did not receive the handouts that were attached to the link for this webinar, shoot your email into the chat box. That's where I will be. So I will be able to help you out, like I said, with any technical difficulties, or if you need the handouts resent to you. There is going to be a quick 30-second survey at the end of this webinar. Please take that 30 seconds to fill it out, because your feedback is super helpful to us. We are here to serve you and to give you the best information and webinar experience that we can, and your feedback is super helpful in us being able to do that. This webinar is being recorded and will be available later in the week on the Monterey County Workforce Development Board's website, so you can look for that as well. So now I'd like to go ahead and introduce Jerry Hernandez, the Management Analyst and Business Services with Monterey County Workforce Development Board. So Jerry,
thank you. Appreciate it. First of all, I want to welcome all of you. Thank you for being with us. The Monterey County Workforce Board is interested in helping you in a number of ways, recognizing the fact that we've all been affected by the last couple of years. It's been brutal on the business community, but we're here to help you in various ways, particularly to help to stabilize, strengthen, and grow your business. We do this in 3 ways primarily. We have recruitments such as job and career fairs that are available to you. Yesterday, we had a virtual job fair. We had nice attendance, by the way. Last year, we had a year of virtual job fairs once a month throughout the year. And we had an average of about 50% turnout rate. We found out yesterday that bumped up to 60%. And nationally, the company that is hosting our virtual job fairs saying that they are finding now that the trend is going 60 to 70% attendees to the virtual fair. So hopefully we'll start seeing more opportunities for job seekers to start connecting with your business. We also have customized recruitment, which means we can have a recruitment just for your business. We have job boards that you're able to post your jobs, and we have other promotional activities. Strengthening the business means to help to nurture your workforce. We have a program called the Incumbent Worker Training Program. If you have existing employees, we're able to help offset the training cost to upskill those individuals. For entry-level workers, we have the on-the-job training program, which allows us to pay 50% of the training cost. And then we want to work with you so that you don't have to lay off if your circumstances allow you. We try to work proactively with you to see what we can do to help you retain your workers. There are other resources that we have available to help grow your business. We have some micro grants that we have occasionally. Within the next 30, 60 days, we'll have some ones that are targeted to micro businesses, 5 and less individuals, about $2,500 or so. We have the human service hotline, which will be spoken of after this slide. other resources for those individuals that are providing, wanting to get into business and grow their business. And should the opportunity unfortunately come up that you have to make a determination about laying off employees, we have a program called Rapid Response, which allows us to work with EDD and then help to transition individuals out of the workforce and then look at other opportunities for them. So I just wanted to share some of our services, and now we'll go ahead and transition the slides over to Astrid. By the way, this is my contact information. You can reach me by phone 755-5393. There's my email address and our website address. This slide will be shown at the end of the presentation, so please feel free to contact us. Astrid, it's up to you.
Thank you, Jerry. I appreciate that. And just a little bit more about our partnership with Workforce Development. You do get a free HR hotline. So your county has provided this hotline number that you're seeing here. And this is a great resource. We love partnering with Workforce Development Board of Monterey County. We have heard from some of you already, which we enjoy helping and assisting you. And so for those of you who are unfamiliar, you have a hotline that your county provides for any HR related support. So our company will help you everything from hiring to firing, everything in between. So anything that you need to onboard your employees, questions you have about benefits such as paid sick leave, FMLA, leave of absence, any kind of wage and hour issue that you might be having. The topic we're talking about today, employee handbook, supporting you through the kind of verbiage and language to include. We have information on harassment prevention, remote work, and of course, COVID-19, which is a hot topic right now. We have a completely free resource page for COVID-19 that includes templates that any employer can use. So any required postings and templates related to COVID-19 are all available on our website at employers.org. And again, you have this hotline, please write down that number so that you can give us a call. And this is a no cost HR hotline to you. So we hope to hear from you all in the coming weeks. And Eli, my partner, is going to be, my coworker will be entertaining you with the second half of this employee handbook presentation. So if you have any questions or answers, again, Tara mentioned it earlier, there's a Q&A button there that you can select and put your questions on there for Eli and I. Eli will cover the questions and answers for me while I'm presenting, and I will cover for him while he's presenting in the second half. And then use your chat if you have any technical questions or you need to talk to Tara about anything, any handout related email things that you need from her. Okay, a little bit more about who we are. I mentioned the partnership we have with you for the hotline. Well, we're also an HR support. You can actually have membership with our company if you go to employers.org. And we offer, if you need more support than the HR hotline, we provide what we call peace of mind to our employers in California. Not only do we offer that hotline, but we also offer templates and handouts and fact sheets and policies about a wide variety. Now, the COVID-19 things are free, but we also offer all kinds of new hire forms, termination packets, things like that for employers. We provide training, harassment training, all kinds of training, management, supervisor training, HR training. And then we also do investigations. We help with negotiations and workplace issues. So if you're needing a little bit more support in the HR world and you need to expand maybe the support that you need, give us a call and look and see if a membership is something that makes sense to your business. Now, although we have attorneys on our team, CEA does not offer legal advice. We are an HR consulting company. So if you have an issue of legal significance to your company, either throughout this webinar or throughout your partnership with us, please consult your own retained attorney. That way that information is confidential and can be kept between the two of you. Okay, so with that being said, we're going to get started here with our handbook webinar presentation. We're glad you're here. We're going to be discussing our handbook benefits and risks. Now, there aren't a ton of risks, but we will discuss what we mean by that in the future slide here. We'll talk about essential provisions, what you must and are required to provide in your handbook so that there is no misunderstanding between your relationship with the employee. Best practices, maybe something that isn't necessarily required by law, but might keep you out of trouble legally and including that. So we'll talk about what those best practices are and why we strongly recommend you include them. We'll talk about reviewing and editing, when you should and shouldn't do that. and then annual checkups at least, and other reminders of where you are in your handbook process. So that's the goal for today. Among other things, we'll cover some Q&A at the end as well. Again, we're going to leave quite a bit of chunk of time at the end for questions and answers, but if you have them throughout, feel free to throw them out at us, okay? So some handbook information here, your benefits of why you should have one. First of all, it's your first line of defense, right? It's your sword and shield to defend you against any kind of lawsuit or any kind of charge that an employee may bring against you as an employer. It tells your employees you intend to follow the law, and these are the policies and expectations that you have of them. So we'll go through here in order here, the confirmation of your at-will employment, which we'll discuss in a future slide, why that's so important, what an at-will employment is, what is the verbiage that you're supposed to have with it, but you want to include a confirmation of that at-will employment in both your offer letters and then when the employee relationship starts in your handbook. That's like the first thing we include. And then the explanation of policies, again, because this is telling employees, here's what we expect of you. And it helps end those bad relationships quickly. If you happen to not have someone, it's just not going to work out and you know it, and why are we going to drag this out? If you have clearly defined explanation of policies, you don't have to keep that employee forever. So that's going to be another way that will help you. It's also going to set the expectations of employees, what we expect of them. Uniformity and consistency, because that protects you against any kind of legal charge. If you're consistent with your policies and how you apply your handbook, then not only does it set a positive tone that you're an ethical company, that you do things well by your employees, but it's also going to help you defend yourself against any kind of claim, because this is how we do it all the time. It wasn't because this person belonged to this group with protected classification. It's because we are uniform, we consistently apply our policy. And then it also benefits you from a defensive harassment claim, because that is required, having a harassment policy. And we'll discuss the details of what you have to include in that harassment claim policy. So it's going to defend you against that. Union avoidance, which we're finding more and more of, is becoming something big, right? Unions, and we want to avoid that. And so if we have a handbook that sets a positive tone, that starts the working relationship right, that clearly defines what is expected of them and what who you are as a company, your mission statement, all that good stuff, then you may have a chance of avoiding any kind of organization of union organizing in your company. But the number one rule is it sets that positive tone for your business, which again helps all these things come into play here, and it just connects them very well to start off on the right foot. Okay, you want your company to stand out too, because as Jerry mentioned, recruiting is difficult right now. We have multiple employees looking and vetting in companies. Where do I want to work? So if you have a handbook, if you have a culture that really sets the tone for who you are as a company, then you may attract the best qualified, not only the best qualified employee, but one that matches what you're seeking out, a good mission statement, good ethics, that kind of thing. So we want to stand out from other employers and that they choose us. Okay, so the risks, what are they? What to avoid? The downsides of an employee handbook are really that if you're following your handbook and everything's good with your handbook, there is no risk. The problem is when you're not following the policies, you're not following what the handbook states, you're not reviewing it and updating it when you should. And so your policies may be outdated. And in fact, they may be illegal. They may be things that were applied but no longer apply now, which is very dangerous. If you're just looking at the internet and downloading a random version of a handbook, that's a big deal, right? We can't be doing that because we don't know if it's California compliant, which is in California, we have to have specific policies, as you imagine. So we want to make sure we're not just borrowing one or coming up with, we're just going to put it together. That's where you're going to have risk. So we want to make sure we avoid those things and do it right. So creating your handbook, you're going to assess your current policies, your new policies, what's required, what do we want to have in our handbook. The point is you want to tell your employees what is expected of them and what are the consequences, what's going to happen if you don't. So the ideal handbook has policies that are carefully and clearly worded. We're not using a lot of legal jargon, okay? We're not confusing employees as to what's expected of them. It's going to accurately reflect your policies, and you're consistent with applicable legal requirements. Here's what we're supposed to do, here's what's required, and we'll go through things that you must have in your handbook. And we're showing employees we are including all these things, not only because we have to, but because we believe in them. And that's going to help you if you're scrutinized by agencies. If there's a charge, such as a state agency looking into your practices, then it's going to defend you against that. It's also going to defend you if you have a lawyer that wants to sue you. You're showing these policies in a handbook, showing that you know the law and you intend to comply. And you're writing in a way where it's understood by the audience. Again, not using all this legal jargon that's hard for employees to follow. We don't want that. We want easily defined words, not using things that lawyers use and that it's hard for most people to understand, and not a snooze fest. We don't want it to be 100 pages long. So keeping all these things in mind and being creative. Some employers are getting very creative in the way they write their handbooks, but this is a good way to, but we just want to make sure we do it right. So a lot of people have what we call a policy manual. And so we wanted to discuss kind of the differences between a handbook and a policy manual, and why we encourage you to have it in two different documents when it comes to this, because there are differences here. You don't want to include both in the same book, because you're going to end up with, again, 100 pages that nobody's going to read. The handbook is your general applicable policies, and it's abbreviated coverage, and it's for everyone to know how we do things and why we do things. What's the value? You're telling your employees things like your code of conduct, your ethics, your values, your standards, your policies, and the consequences, and information about their investment in your company and how that's going to impact them. So what does this mean? My relationship with my employer. The policy manual, on the other hand, is work related. It's related to their job. How do they do their job? What are the procedures? If I'm an opening employee, what's the opening procedure? I need to unlock the door. What is the procedure? If I'm a cash register person, what do I need to do? Do I need to count the money at the end of the day? What is the procedure? Those are all things that shouldn't be included in your handbook. That's more of a policy manual. These things can change. It's going to be dependent on their job duties. So these are just procedures, and it goes into detail. And sometimes it's really more for our managers and supervisors to have on hand. And again, they can be related, and you should reference your handbook, because if they're not following the policy, then there's consequences, and those are mentioned in the handbook. So just know the differences. And again, a recommendation here is that we keep them separated because they have different purposes. So again, the essentials, let's cover the basics, what's required, and then what's best practices, and all the others you may want to consider. So if you're a supervisor, manager, business owner, you've probably heard some of these things. You can't change my job description. Do we have to give 2 weeks notice at this company? What if my coworker makes me uncomfortable? What do I do? Where do I go? Who do I go to? My friend who is a lawyer says, you have to give me that time off and pay me, and by tomorrow. Do I get paid for holidays? How much vacation do I get each year? What if I don't want to take my breaks? And a lot of times we get calls like this into the hotline. Do I have to pay them for a holiday? They say they need to give, they don't want to give 2 weeks notice. Is that okay? And always we say, look at your handbook. What does your handbook say? Your handbook should be able to answer these questions. So if you currently do not have a handbook, then you may be inconsistently applying all these things. And as you get these requests, you're going to handle them differently, possibly. So you want to become a unified voice in your company, knowing how to answer every single one of these questions that are laid out here. Some of these, again, not completely the law required, but again, best practices so that you do a good job at being consistent. So here are some important statements that we talked about earlier. We want to include in our handbooks. The first one is that the employee or employer can change the terms and conditions of employment, meaning anything like termination, demotion, transfer, or reassignment without advance notice or cause. So that's our statement that we must have in our handbook so that there's no misunderstanding that this is a contract for employment. We're not a contract for employment, we're an at-will employer. The second one is not subject to change except in writing, signed by the employee and an expressly designated company representative. And then the third statement we want to include is this included an integration clause. So this handbook supersedes prior agreements. We want to make sure that if there's other copies of handbooks, maybe you have a long-term employee who's worked with you for a very long time, you want to be able to say this supersedes anything that came prior. The new laws will apply. Now, if you have some grandfathered policies because you have a 20-year employee who maybe the benefits were different and you want to honor that, which you don't have to, but if you wanted to, then you can go ahead and grandfather that into your new handbook, but be very clear about what it is you're grandfathering in and for who. Okay, so a little bit more about being inconsistent. It can lead to discrimination and harassment prevention claims. So we want to make decisions when we're making employment decisions about work-related factors. So performance, we're looking at performance and we're consistently applying these things. Maybe they're just not cut out for the position. We hired them, we thought they were qualified, but they're just not working out. And that's okay. We're going to follow our policy in how we deal with work performance. What is it that we do? What are the steps? Do we have to have it be long-winded if we know they're not working out? And you don't, right? You don't have to wait 90 days. Sometimes people put that probation period, which there is no legal probation period in California. In fact, we don't, again, want to put a term of conditions. We don't want to say you have a probation period and then we will evaluate. If at day 3, you know they're not going to work out, we don't need to have this long-winded relationship with you. We're going to give you opportunities. We might give you a warning. We might give you more training, but we're going to deal with performance a little bit different. Same thing with attendance issues. Be clear about your attendance policy. We have this, sometimes we get calls with this great employee does so well for us and he misses a ton of time, but you know what, he's really good when he's here. And so we overlook our attendance policies. But then this other person who is annoying and is constantly complaining to us, we're really going to hone in our attendance policy on this individual. And this is going to create this inconsistency, which again may lead to these discrimination and harassment claims. That's when we see them. Safety violations is a big one right now with COVID-19. More than ever, we're seeing safety violations. So ensuring that we have what we need at minimal to provide for our employers to keep them safe, and then ensure that if they are bringing safety concerns to us, we're taking them seriously. We want them to come to us before they go to an outside agency and file a claim against us. And then what happens if there is a violation of company policy? You should have the steps of what happens if there is a violation of policy. And this is why a handbook is very important. You're going to lay out the steps there. You're going to say that we can skip steps in the process at any time. We also want you to know all of the protected classes because we do need to list them out in your handbook. If you're unfamiliar with what those protected classes are in California, we're going to show you in a minute what they are. There's a lot, so be ready. There's about 18 of them. So we'll show you them. You don't have to memorize them, but we will kind of go over and review some of them. A little bit more about harassment prevention, because this is a requirement in California. A clearly written harassment policy is required of all employers. You need to make a statement that harassment is illegal and will not be tolerated. You're going to list all those protected categories, which I will show you in the next slide. You're going to make a statement that the law's prohibition of coworkers and third parties. You're going to talk about that, as well as supervisors from engaging in prohibited conduct. You're going to have an anti-retaliation statement saying that we do not tolerate any kind of retaliation for bringing forward a complaint or for participating in an investigation. You're going to list the contact information and the training links. And by the way, we give this information out too in training. So if you have a harassment training, that needs to be included in your harassment training. And that's the Department of Fair Employment Housing, the state agency that handles harassment claims. And then it's equivalent in the federal world, which is the EEOC. And that's where the harassment and discrimination and retaliation agencies live. And so you have to provide them with that information as well as with the training links there. And then list out your detailed complaint process. So not only are you going to have all these bullet points here on the right, but you're going to have a plan in place with your supervisors on how this is going to function in your company. You're going to have a statement of confidentiality, that you're going to respond to the complaint in a timely fashion, because time is of the essence with harassment prevention and harassment claims. California requires a timely response. Impartial and timely investigation. We're not going to wait until the boss gets back from vacation. We're going to do this right away. It cannot wait. Now, if it has to wait by a day or two and there's a legitimate reason why, you're going to list out that information as to why. But it really needs to be timely. And impartial meaning if you're just too close to the situation, if you're a small business and everyone knows each other and you're in each other's business, you may need to remove yourself from that and contact someone else to help you and assist with that investigation. You're going to document and track for reasonable progress, and you're going to offer options for remedial actions and or resolutions. And then what are we going to do if we do find that someone is guilty of harassment? And then you're going to have a timely closure. Probably the number one complaint we get when we do harassment training is that they never got back to me. So we want to make sure that we close the loop and we have a timely closure to that investigation that we've done. And then here's a pro tip we want to mention. If 10% or more of employees speak a language other than English, you must have this policy translated. So ensure that you get this information. And again, if you have 10% or more of your employees that speak that different language, get that policy translated. It is required. So here are the protected classes in California. And as you can see, everyone is protected in California. Again, you don't need to memorize them all, but just know that taking any kind of adverse action on an employment decision, when you're doing anything adverse related, any kind of termination, written warning, denying someone's day off, that kind of thing, ensure you're analyzing and checking these protected classes so that you don't inadvertently discriminate against someone. So sometimes I give this example in my training where we have an employee who's pregnant, who's getting further along in her term, and she's slowing down. She's got various medical appointments, and the manager feels bad for her and says, you know, she's slowing down a little bit. And in good faith on their part, they're thinking they're doing the right thing by excluding her from meetings. They are now not having her participate in the planning process of something that's new to the company, and the employee's feeling left out. Manager thinks, I'm doing a nice thing by not putting more on her plate. Employee's perception is, I'm being treated different because I'm pregnant, and that is a fact. So we need to be careful to train our supervisors, our management, to not their good deed, what they think might be a good deed, may be something they're doing that's against the law. So we need to be aware of some of these things. I just want to point out a few. Perceived status, because sometimes people get confused by that, is maybe something I perceive you to be or belong into. Maybe I think you're a certain race or a certain religion or a certain gender identity, and I treat you differently, or I do something, adverse action against you because of that perceived status, even though it may result that that's not true. You don't belong in that protected class. Another one we like to point out is also association based on status. So maybe I'm associated with someone who is in a protected class and I'm being treated differently. Maybe if I've applied to a job and I'm married to someone who's Jewish and the employer says, I don't hire anyone who's associated with Jewish people. So that would be association based on status. So again, when you're making an adverse action, when I used to do investigations and discipline and employee relations, I get managers call me and say, I want to write up this person. And we'd always, one of the things in our analysis was to check the protected class, just to ensure we weren't doing anything inappropriate or the appearance of something like that. And if it did appear that way and the employee still deserved the adverse action, we wouldn't just say, oh, forget it, it's going to look like we're discriminating, but we would just treat it with a little bit more delicately, analyze it a little bit further, and just maybe even talk to an outside counsel, an attorney, to see if it's looking okay before proceeding. So just use caution if that's what it's looking like. Okay, we're going to transition into the required leaves of absence policies. And again, these policies that we'll talk about are required. They don't necessarily have to be in a handbook, but that's why this is all good. To have it all together in a handbook would be your best line of defense. And why have all these separate little policies? It's best to just put them all in the handbook. So although not required necessarily for this handbook, it is something that is quite often confused by employers. We still get tons of questions regarding sick leave. And so we want to make sure that you're aware of the Healthy Workplace, Healthy Families Act, that are known as the California Sick Leave. It provides 3 days or 24 hours of paid time off and job protection for all employees to address their own health needs or the ones of their family members. And this has been changed here and there. So this is current information we want to review quickly, that you have this information again, because it's a lot of times very much misunderstood. So you can pick one of these options, either the accrual method, accrue 1 hour for every 30 worked. You can cap it at that 48 and limit the use for 24 hours. Or you can pick the lump sum method, which is probably recommended and easier to follow, where you just grant an employee the lump sum of 3 days or 24 hours a year, and then it expires at the end of the year, and then you start over again. And you can require with both of these to wait until 90 days to use paid sick leave. Again, we highly recommend this. If you're in a high turnover industry, you're going to want to limit the use of this until they get to 90 days. It doesn't mean they're not accruing it. They are accruing it, but you do not allow them to use it until 90 days. And sick leave is never paid out unless it's part of a PTO plan. So make sure we want to keep it separate from PTO plans because of this reason. And then include that employer may not retaliate. Train your supervisors and management on this. You cannot retaliate if an employee requests sick leave. And retaliation looks like, no, you can't take that sick day. That would be could be perceived as retaliation. An employee can always use their sick time. We cannot prevent them from using it. The PTO combined plan that I talked about earlier, again, you can combine it and put it into a PTO that combines vacation and sick. But you have to pay that out because vacation is paid out in California. So if you have a PTO combined plan, again, you got to treat it the same way as you would sick. So if you had two separate policies, the vacation you can control and deny and pay out. The sick leave you have to grant, you have to allow them to use it. So if it's combined, then the sick leave rules apply to your entire PTO plan. So that's where it works for some companies, but it may not work for all. Be aware that you may be in a county or ordinance or a city that requires additional time off. So make sure we have actually our resource webpage here that you can link to find out if you have employees working in different counties and different cities throughout the state. You may have a sick leave that you need to comply with, as well as minimum wage while we're at it. So just ensure that you take a quick look there at that link to make sure that you are aware of what's required where your employee works, if they're working remotely from where you are. Okay, we have a pregnancy disability leave as well, this PDL, pregnancy disability leave. Employees are eligible for this from the first day of work. And this is for all employers with 5 or more employees in the current year, or if they had 5 or more employees in the previous year for 20 consecutive weeks, then you are an employer that must provide pregnancy disability leave. An employee is covered anytime a healthcare provider states that that employee cannot perform or work their essential functions of their job without undue risk to themselves. So that is what's required, a medical note taking them out. And it could be for a day or two, like for morning sickness. It could be an ongoing thing where a doctor's note says they may intermittently take time off prior to the baby being born. And it may be a couple of weeks, maybe 3 or 4 weeks before the baby is born, they take out, that's PDL. And then it also covers them when they have the baby. A woman is usually disabled for 6 to 8 weeks after. So that's also all related to pregnancy disability leave. So it can occur before, during, or after the actual birth. How much time does this employee get? Up to 4 months. And then you'll see the equivalents in weeks, days, and hours there. The amount of leave is per pregnancy, so be careful, it's not per year, and there is no limit. So if an employee has unfortunately miscarries and gets pregnant again, it's per pregnancy. Leave can be used all at once or intermittently, like I described earlier. It may be that they're on bed rest and then they're not anymore. Maybe they need, they have morning sickness and they need to be covered during that time. It can require employees to choose, employer can require the employee to use sick leave during this time. That's pretty much the only time you can require sick leave is through pregnancy disability leave, but we can't require the use of vacation or PTO, but the employee may choose to do so. So just understand the differences there on number 4 listed here. The time off, the time needed must be certified by healthcare providers. That does help employers. Please request that medical form. Sometimes employers are busy and we skip this step and then we're left with an employee who we don't know when they're going to return. So please get that medical certification from that employee so that we know how to plan and how far do we need to protect their job from job protection. I actually just got a call like this yesterday where an employer said, you know, we never designated, we never requested anything from the employee and they've been out forever and we really need to replace them. and they had skipped so many steps that they really didn't know where to begin. So we had to backtrack and look at everything and start over from what they should have done 4 months earlier. So don't get stuck in that. It can easily happen, even if you think it's not. The California Family Rights Act is something that is also for employers with 5 or more employees. It provides up to 12 weeks of unpaid benefits for eligible employees. An employee is eligible if they work for you for 12 months, and they don't have to be consecutive, and 1,250 hours in that prior 12 months. So that's typically your full-time employee. And the covered reasons under CFRA are listed here. You can see that. It is for the birth of a child, but it's different from PDL because the birth of a child under CFRA is only for baby bonding. So CFRA cannot start until the employee is no longer disabled. So for that 6 to 8 weeks after the woman is released from her doctor, and at that point, CFRA would start for the baby bonding. And we have a much longer webinar on leave of absence if you need more details. This is just a quick snapshot of things you should include in your handbook. Some of the qualified family members, because it's not only for the employee's own health condition, but that of their family members. So there's some other things that exist there for active duty as well as it relates to the CFRA. And then FMLA, which most of us are familiar with, is a federal leave of absence. And this is for our larger employers with 50 or more employees. And this is providing, again, the same thing, that 12 weeks in a 12-month period. Employees are eligible if they work at a location with 50 or more employees in a 75-mile radius. And again, have worked with you for that 12 months and that same 1250 hours. Many times the CFRA and the FMLA run concurrently. They're the same thing. But there are times, depending especially on the reason why you're taking it, then the CFRA may apply and the FMLA won't. And so you need to be careful on the reason why they're taking the leave, okay? Because the reasons are different for both of these leaves. And again, if you're a small employer, this won't apply to you, but the CFRA will. Okay, so most employers use one of the following methods on how to define that leave of absence period for both FMLA and CFRA. Some people can use, some people would like to use the calendar year, and that's okay, or any fixed 12-month leave year, such as a fiscal year. People use July to June. Sometimes employers use the employee's anniversary date to look at that 12-month. But in both these instances, we're going to say be cautious because you might end up in a situation where an employee takes leave one right after the other. If it's in the calendar year and you have someone going out in August and they take their 3 months, and then in January, they will be eligible once again. Same thing applies to that fixed 12-month. Maybe they came back from leave in July and they will be eligible again in June. So be careful when you're doing the calendar or fixed year. We recommend that third method, which is the 12-month period measured forward from the date the employee first requested leave. So you're going to look at when did that employee request leave and look back 12 months to see if they've taken a prior leave. You must select one method and it needs to be clearly stated. It can't be the day you ask me, I'll decide which one I do. And you need to stick with it consistently with all your employees. So you want this in writing. How is it that we define when that leave period begins for a look back period? So make sure you look at those options. If you don't have one, when you get a handbook through us, we will ask these questions. How do you want it? We're going to really pitch you number 3 because we want you to use that one. But again, you want to make sure that you pick one, select one, put it in writing so employees know what it is they follow and how they're eligible. Last slide here before I turn it over to my coworker, Eli, some more protected leaves. You know, there's a lot. And again, this is what the hotline is for. Give us a call. We'll go through whether it applies to you, how it applies to you. I don't want to include all the definitions because this is not a leave of absence webinar, but we do want to mention them so that you're aware. And these are all good ideas to keep in your handbook, because if you're required to provide them, then you need to put them in writing. So again, the bone marrow organ donation, those are for 15 or more employees. That requires you to provide leave of absence for them. Crime victims, all California employers have to provide crime victims with time off to handle things such as legal matters. You have to provide reasonable accommodation to them. If you're an employer with 25 or more, then you have to provide time off if they need medical treatment or psychological treatment or safety planning, that kind of thing. But for all employers, you have to provide time off for things like restraining orders, court hearings, things like that. Emergency duties is for all employers to have to provide time off for emergency services, those employees who are registered that way. Drug, alcohol, I'm sorry, I skipped one here. Civil Air Patrol, that's one that may or may not apply to you depending on your head count. Drug, alcohol rehab is when an employee requests assistance or help. If they tell you, you know, I'm just not doing well, I need to enter a program, they need to be reasonably accommodated by allowing time off to go into rehab, and that job is protected. Jury duty doesn't have to be paid, although there is something that the legislators are working out in future bills. You may want to watch out. They are wanting to have employers pay for jury duty. But as of now, that is not a requirement for private employers to pay for jury duty. Many employers offer that as a benefit, but it's not required. But what is required is for you to allow them to go. You cannot prevent them from going to jury duty. You just don't have to pay them. There's other medical leaves of absence under workers' comp, under ADA, Fair Employment Housing Act, so any kind of accommodation. So even if an employee is not eligible for a leave of absence for CFRA, maybe they haven't been with you long enough, maybe you're a very small employer, but you still need to consider the request for medical leave. Maybe they've exhausted their leave of absence and they require additional time. All that needs to be looked under the ADA, the Americans with Disabilities Act. There's voting time, and by the way, that voting time is on that poster that you should have up in your break room or wherever you have it in your place of business. There's family, school, and childcare partnership leave, and that's typically for 25 and over. It allows employees to go to their child's school, maybe watch a play, maybe help with a party, that kind of thing. There's also school suspension. So on the other spectrum, if the employee's child is suspended and they need to attend to that for a meeting, that is allowed as well. Military service, military spousal leave for 25 and over, they get some time off as well for that. So be aware that these exist. Give us a call if someone asks for anything like this, and then we'll get you going there on the details. But definitely, if you're an employer with 15, 25 or more, many of these are going to apply, and we want you to include them in your handbook. So I will turn it over to Eli so I can get some rest, but please continue with your questions as they come on, as you listen to some content. And I'll stop sharing here, Eli, so that you can get your screen going.
Of course. Thank
Do
you,
we have
Esther.
any questions right now that we need to answer?
No questions out there right now. I'm sure, you know, we'll see some more pop up as we go. But no questions in the first half. I mean, covered quite a bit, quite a lot of information for everybody. And you know, hopefully everybody's head isn't spinning right now trying to wrap their head around it. So, but with that, you know, thank you, Esther. As we go along too, just make sure if you have any questions, go ahead and put them in the Q&A box, and then we'll either answer them as we go or, you know, save them for the end as well and discuss them for everybody to see. So, I'm going to take over now and discuss some of our wage and hour policies that, you know, should probably be present in your handbook as well. Some of the details for them and the reasons why, along with some of the pitfalls that come with them as well. You know, some things you should be aware of. And this is all based on, you know, experience we've had with some of the handbooks, but also some of the questions we get from members, from hotlines, that sort of thing. So, you know, these are some of the common things, and, you know, some things that could be addressed with your handbook. So for starters, we have the overtime requirement, right? And that's very important. You know, I mean, I know staffing's hard. Staffing's hard in a lot of industries right now. You know, people have to work a lot of extra hours to cover shifts, get the job done, get everything out and everything. So we want to make sure that your overtime requirements are spelled out in your handbook, right? You want to make sure there's a notice, and these are requirements that should also be posted with all the other labor information for your employees, along with your specific wage orders. But for starters, we have overtime for over 8 hours a day. You have to pay 1.5 hours the regular rate of pay. You know, make sure that that's in there, as well as over 40 hours in the work week. So some states have it, you know, where it's just 40 hours in the work week. Anything over 40, you have to pay overtime. California is a combination of both. So make sure that's clear in there, that anything over 8 hours in the workday is overtime. Anything over 40 hours in the work week is also overtime as well. Now, if you're in a situation where you have employees that work a 7th day in the same work week, and we'll discuss the difference between work week and just a week in the future slide, make sure, you know, those first 8 hours worked on that 7th day in the work week are all paid at 1.5 times as well. So it doesn't have to do it for the 6th day, but for the 7th day in the work week, you do have to pay 1.5 times. basically as soon as they clock in on that 7th day, right? Then there's also 2 times the regular rate of pay or double time. That's for any work that's done in excess of 12 hours a day or after the 8th hour on the 7th day on the work week. Now, keep in mind, it's just the standard overtime rate. If you're in an industry such as agriculture, this may be a little different, although that's becoming more in line with what is standard now. But this is more or less the regular overtime regulations. Now, if you're a company or an industry that employs minors, be aware that requiring minors to work more than 8 hours in one workday, whether you pay overtime or not, that could be a misdemeanor. So make sure if you're hiring minors for your work or in your company, you're limiting that work time to 8 hours a day or to the at the most, or to that standard work day, right? Some of the potential issues with not paying that overtime correctly or not paying people correctly. Obviously, you could have a claim filed with the state, or there could be civil actions. Many of us have heard the word about PAGA claims, the Private Attorney General Act, that allows attorneys to come in and actually start going for some of these missing pays or late pay or anything like that. In my position, I travel up and down the valley a little, visit members, and I could see a lot of billboards, that say, hey, have you been paid correctly? Did your manager not pay you overtime? Did you not get paid for COVID pay or whatever? Give us a call. So, keep in mind, not paying an employee correctly can open you up to some liability, open you up to some issues there. Okay. Very important too, now we're talking about minimum wage and overtime and that sort of thing, is you want to make sure that your handbook defines the workday and the work week. A lot of us may say, well, what's the difference? We work a standard 9 to 5 or 8 to 5 or what have you hours. It doesn't really apply to us. Keep in mind, if you're ever in a position where your shifts kind of overlap from one day to another, maybe you have a second shift or graveyard shift, you want to make sure that you're defining what the workday is, because that's going to affect how you pay that overtime or how you should be paying that overtime, what hours count to the total overtime tally, that sort of thing. Traditionally, most people, or a lot of people, define the workday as starting at midnight and running to 11:59 p.m. So, basically one day, one calendar day, that's your workday. You want to make sure that that's defined though. And in some businesses, it makes sense to shift that around a little bit. So you want to make sure that's defined in your handbooks, your employees are aware of it. And so that they're, it helps to explain any kind of overtime questions, pay questions, that sort of thing. Same thing goes with the work week too, right? You're going to pick any 7 consecutive days. Again, traditionally, you could follow the regular work week, from Sunday to Saturday. But in some industries, it may be beneficial to run it differently. Maybe it makes sense, if you ship a lot of things, or if you're in manufacturing, maybe it makes sense to make your work week run from Monday through Sunday, or from Saturday to Friday or anything like that. So whatever it is, just make sure that once you pick it, again, much like that 12-week calendar Astrid mentioned earlier, make sure once you pick it, you define it, you stick by it, put it in your handbook, right? This can also affect, that 7-day work week. That's going to affect how you pay overtime if your employees work that 7th day, right? The other thing is, a lot of questions that we've gotten before is, hey, my employees say that they can't work 7 days in a row, or they, the law says this or the law says that. And there is some truth to that, right? The law says that on the 7th day of a work week, you can't really force an employee to come in. You can't make it mandatory for them to come in. However, the work week is not always the same as a calendar week, right? And it doesn't mean 7 days in a row, any 7 days in a row. You're looking at the work week, at what you've defined as a work week, whether it's, Sunday through Saturday, Monday through Sunday, whatever it is. That's where you count those 7 days. As soon as the work week ends and the other one starts, boom, the count starts over again. So keep in mind, define what that work week and what that work day is, put it in your handbook, and make sure that your employees are clear on it from day one. Okay. Now, when it comes to breaks and meal periods, there's still an issue to this day. I know, they've been part of the California landscape for a very long time as far as employment laws and that sort of thing. But to this day, we're still seeing a lot of costly wage and hour claims come from this. And, at the very least, sometimes employers have to pay the meal penalties or the missed break penalties or something like that. But if you go to an extreme, then there could be, class actions or things like that for missed meal periods, meal breaks, that sort of thing. So make sure your handbook has a section in it that talks about the meal and break period policy in there. And we'll go into details about what they should be for each one of them in a sec, but make sure you're defining that in your handbook for your employees to, understand, sign off on, reference in the future and everything, right? This of course applies to non-exempt employees. They're the ones that are bound by these meal and break periods. Your exempt employees, doesn't really apply there either. And your first line of defense with this, as with many other things, is going to be your managers, your supervisors, your frontline people, the ones that are out there dealing with the employees. If you have several layers of management, you want to make sure that they're familiar with meal and break, regulations, laws. When are these breaks taken? What do I do if this happens? That sort of thing, right? So again, they're going to be your first line of defense in this, and and many other things, right? And the thing to remember, I mean, meal periods, break periods, the policies should be fairly comparable, and there's a couple things that overlap on them. One of the big questions we were always asked was, can we require our people to stay on site for their meal break, or can we require people to stay on site for their break period? I mean, the break's only 10 minutes. Where can they go? They're going to be late, right? And the state has weighed in on this, said we can't force people to stay on site, because at that point you're not they're still under your control, so you're not freeing them from control. It's not a true break. So you have to allow your employees to leave, whether it's a break, whether it's a scheduled break or their scheduled meal. They need to be allowed to leave the premises, whether it's to go out and get a bite to eat at a restaurant or run down to your local gas station or whatever to get a snack. They are allowed to leave. So look a little more in depth into rest breaks or your break times. A lot of employees always say, oh, well, you owe me a break at exactly 2 hours after the start of the shift, or I come in at 8, my break has to be at 10 o'clock. That's 2 hours in or whatever. And this is why you want to define this in your handbook, right? Now, California law basically says, or all it says, that employers have to authorize and permit an employee to take a 10-minute net rest break for every 4 hours worked, and that it should be in the middle or as close to the middle of the work period as practicable, right? It doesn't say it has to be exactly 2 hours in or exactly in the middle of it. It has to be as close to it as possible, right? The other thing is, when we're talking about the net rest time for every 4 hours worked, it's 10 minutes of net time. So if you have requirements like your employees have to wear specific safety gear that they have to put on and take off, or don and doff, if they have to take any specific steps like power down the machine or power it up, at the beginning or at the other break or anything, that is compensable time. That is not part of the break. So it has to be a net 10-minute break time minimum. And that's why a lot of companies do 15-minute breaks instead, right? Because, even if you say it's 15 minutes, but you have maybe 30 seconds, 1 minute that are spent, doing some of those work duties, you're not violating that 10-minute law. So make sure that, you keep that in mind, and make sure that your supervisors know that too, right? Because a lot of times, they want to blow the whistle and say everybody go on break, and then at exactly 9 minutes 59 seconds they want to blow the whistle and have everybody be back at their station, or be back at the line again, or what have you. And it has to be 10 minutes of rest. So let's see, these rest periods, you don't have to record them on a time card, so people don't have to clock in or clock out for them. Sometimes employees sign into time cards and there'll be a question saying, I received all my meal and rest breaks for the week or what have you. That's fine, but it's not something that has to be recorded every time they take the break. As I mentioned, you can't require your employees to stay on the premises. You have to allow them to leave if they want to. Now, you can hold them to the time limit. You have to say, you have to be back at a reasonable time, say, 11 minutes or what have you, but you can't say that you cannot leave, because at that point you're exercising control over them and it's not a true break. And finally, if you fail to provide a rest break for your employees, that is a 1 hour penalty at the regular rate of pay. And that's total for any workday. So that's only if you fail to provide. Now, if you give your employee a break time and they choose to work through it, that's a different story. We recommend you find a way to document that they basically waived that break, and it wasn't something that they were asked or coerced by management or by the company to do so. Because if that's the case, then you are liable for that 1 hour penalty. jumping over to meal breaks or lunches. Once again, state law says, there's got to be a minimum of a 30-minute break if the employee works more than 5 hours in a day, right? So if your employee is going to work more than 5 hours, by law, they have to have that 30-minute break. The exception to that, of course, if they're going to work less than 6 hours, not 6 hours, less than 6 hours, they can choose to waive that meal period. We recommend if you're going to do that, you get that waiver, at least a one-time waiver, something in writing or something that says that they understand that. Maybe even put in your policy that, or in your handbook that says, employees, if you're going to work 6 hours or less, you can choose to waive your meal break, right? That meal break must start before the end of the 5th hour. In other words, before they hit 4 hours and 59 seconds into their shift, they got to be on that meal break, right? That's why it's recommended. Maybe you stick closer to that 4-hour mark. So you're not you're not going over that 5th hour and then you owe that penalty again. Again, such as with breaks, they must be relieved of all job duties. So in other words, you can't say, yeah, you're on your break, but just keep an eye on this machine or answer the phones or just monitor the emails while you take your lunch or something, because at that point they're not being relieved of all their job duties. And again, the penalty for failing to provide that meal break is that 1 hour at the regular rate of pay. And again, employers are only required to provide that 30-minute meal break if your employee chooses to work through it. It's obviously it's a dangerous proposition, right? Because unless it's very clearly documented and you talk to them to make sure that they know that they were able to take it and they knew that, there could be allegations that they were coerced or the company made them skip it or something. So we recommend that if someone's making the practice of skipping those meal breaks that they're supposed to take, you put a stop to it. Make sure you put it in your handbook that employees are required to take those meal breaks if they're going to work more than 5 hours a day or more than 6, or however you want to write it, right? But make sure that's in your handbook, basically writing out when they're required to take that meal break, how long it needs to be, that sort of thing. Okay. Now, again, the meal and rest policies are pretty comparable. As we said, they have the same rights to leave the premises, whether it's a meal or a rest break. You can't tell them you can leave for your lunches, but you have to stay on site for a break because, it's too short and we want everybody to be back at the station and so on and so forth. Just remember that their meals and their rest breaks are the employees' times. They have to be relieved of all responsibilities, relieved of all duties that the employer places on them. So that is their time to do as they will, right? You can specify that they have to be back at their workstation promptly at the end of break. In other words, if it's a 10-minute break, they leave, they take their 10-minute break, and they have to be promptly back at the end of that 10-minute break, right? Now, be careful there again, if you require them to put on any special gear, if you require them to do any steps before getting back onto the work floor, that time should be compensable. Keep that in mind. What comes to mind is, places like food manufacturing or things like that, where they have to put on a lot of protective gear, hair nets, whatever, smocks or anything like that. Make sure that, you're being careful with that time and you're not charging them for that time for things that you're requiring them to do. And then if employee missed their meal break or their regular break, make sure that you specify that they must document that with their supervisor, right? It could be a form, it could be, requiring to shoot an email or something like that, but make sure you have the documentation because, as Astrid mentioned earlier, sword and shield, that is what's going to protect you in case there is future claims of, wrongdoing, future claims of violations of the law, that sort of thing. Having that documentation goes a very, very long way in protecting you. Okay. Next section that should be in your handbook, or the things recommended to be in your handbooks, relates to workplace benefits and expectations, right? And for benefits, we're talking about things like, vacation. A lot of people think when we say benefits, you're thinking medical, you're thinking dental, that sort of thing. We're going to focus specifically on vacation. We'll touch on those other ones here in a bit and whether you should or should not include them as well. Conduct, what's the employee conduct? What are the do's and don'ts of working with you? Anything to do with profit sharing, right? It's something that's going to be pretty standard and more. So let's jump right into vacation policies. And Astrid touched on this a little bit earlier when she mentioned about PTO, right? So let's get a little bit deeper dive into this and some of the reasons why, the vacation policy should be pretty clearly spelled out in that handbook. The first reason why is that the state of California considers vacation as a form of wages. Not so with paid sick leave if you have separate, right? Paid sick leave is granted. However, vacation is seen as wages. As such, you can't really interfere with it. It's protected. It belongs to the employee. So that's the reason why when an employee terminates and they have vacation in their bank, they get to take that with them because it's earned wages. That's theirs. And doesn't matter what your method of delivering that vacation time is, whether you grant a lump sum at the beginning of the year or whether they accrue it throughout the year. Once you give it to them, once it hits their bank, it's theirs. So make sure that your policy is well written out and very clear about when that vacation is granted, given, or accrued to the employee, whether it's done per week, whether it's done per hour worked, whether it's a lump sum at specific times. Make sure that that's fairly clearly spelled out in your handbook, just in case there's a separation or anything like that. There's no back and forth and about, well, you owe me this much. No, it's only this much, because it should be clearly spelled out in your handbook at that point. Something else the state of California says is if you are going to cap how much vacation can be accrued or carried over, what have you, it's got to be a reasonable cap. And what this means is, many companies say, okay, well, you're going to accrue this much vacation per hour worked for a total of 80 hours per year, right? And then you can carry it over and, so on and so forth. Well, many companies didn't cap that for a long time, and you ended up with people carrying just really, really stratospheric amounts of vacation, to the point where when they retired or left or separated from the company, you're having these huge vacation payouts, right? So the thought was, well, let's put a cap into how much they can accrue. And once they hit that cap, they stop accruing. Sounds like a great idea. State of California said, that's fine. The only thing is it's got to be reasonable. Sounds pretty vague, right? So they came back and said, well, what's reasonable? So what the state of California defined as reasonable is 1.5 times their annual accrual. So for example, if someone accrues 80 hours a year, a reasonable cap for the state of California would be 120. So they can hit up to 120, and then they stop accruing until they drop down below that cap. So make sure that reasonable cap, if you're going to use it, that's spelled out in the handbook, so that people, so you don't have a lot of upset people saying, well, why did I stop accruing? It doesn't say anything in there. You're taking vacation from me. If you have a reasonable cap and it's spelled out in there, it'll defend you from that. Consistency when it comes to vacation policies. Astrid touched about this on leaves as well. If you want to put some kind of guidance in there about about the process for requesting vacation and how you're going to grant it. You don't have to go out and, basically define every single circumstance, because, that could be a couple of volumes of books there if you're getting there, but just, what's going to be our guidelines, and then you want to be consistent when you enforce them, right? You don't want to say, well, I'm going to grant vacation to Joe instead of to Tom because, Joe's dog just died and he was really close to it. And, I think he really needs it, even though Tom asked for it first. Well, maybe Tom lost a cat, we never know. You don't want to let any of those outside circumstances really have an effect. You want to have a policy that's going to kind of define, when that vacation is granted, who gets it, how much, and that way you could go back and stick to it. So there's no claims of favoritism, no claims of discrimination or anything like that. So consistency is going to be key there. Use it or lose it. Since California considers vacation to be wages, basically once they're earned, granted, or hit that bank, you can't take them back away. So you cannot say, oh, well, at the end of the year, if you have any unused vacation, we're going to take it away and you start from zero. Well, sorry, can't do that. That vacation was already granted. It's already theirs. It's their wages. You take it back. Wage theft, right? And if any of you have been to our labor law updates, you know that recently a law passed that allowed wage theft to be classified as grant theft. So be very careful with that, right? Make sure that you don't have a use it or lose it policy. This applies for PTO as well. If you combine your sick time and vacation to one PTO policy, the thing to keep in mind is that the protections for vacation and the protections for sick time both apply to that PTO bucket. So you're kind of putting yourself in a tough spot by using PTO because as a combination bank, because you have to honor basically both of the protections. You have to pay it out, has to be granted for sick time. You can't deny it as you would be able to with vacation, so on and so forth, right? As we said a couple times, vacation must be, any accrued or granted vacation must be paid out at termination, the time of termination. Make sure that's in your handbook. Make sure that's spelled clearly out as well. And then if you're a company that does personal days or floating holidays, be very careful with those as well. Again, the state of California has classified personal days and floating holidays for the most part as similar to vacation as wages. There's a very narrow exception that says that, if you grant personal days or floating holidays and they're tied to strict days, such as, say, we're going to give you 2 personal days, 1 for your birthday and 1 for your anniversary date. If you tie them to a specific date and that repeats over and over, that could be an exception where they're not seen as wages. Otherwise, if you leave it up to the employee's discretion to use whenever they will, guess what? If they have, 2, 4, 6, 8 personal holidays, whatever it is, in their bank and they leave, those are seen as vacation or wages. You have to pay those out. So if you are using personal days or floating holidays, either be aware that you may have to pay those out because, or treat them as vacation, or make sure that they're tied to specific days or events. All right. A word about integrity policies. And what we mean by integrity policies is this is the kind of behaviors, the kind of things you want to see or you want to avoid from your employees, to basically define the expectations, some restrictions that you're going to place on your employees and their behavior. And really what these are to deter any unacceptable behavior, right? And you want to basically support or promote good behavior, but this can also help you if there's any kind of misconduct, if you have to do any termination or anything like that. That's where these policies come in very handy, because these are going to be what you're going to, really lean on, really look into when you go from there. So a couple of these integrity policies that you should have or should consider having, obviously, are your open door policy, right? Very important. I mean, when we talk about union environments and that sort of thing, sometimes a complaint for that is, we don't know who to go to. Nobody listens to us. My supervisors listen to us. There's nobody there for us to talk to, right? So we're gonna, we need to go this other route. Well, if you have that open door policy with many ways for employees to vent or air their concerns, and you're responding to them, it goes a long way in solving a lot of those issues. Employee conduct, things that are acceptable or non-acceptable. Attendance, right? I mean, attendance policies vary as much as companies do, with they vary all over the place. So you want to make sure that you have some kind of an outline in there. Now, even if you have a very intricate attendance policy that's a standalone on outside of the handbook, you want to make sure that you're mentioning something about attendance in your handbook as well. Drugs and alcohol as it relates to testing, workplace violence or weapons in the workplace, right? Sometimes that becomes part of the or is mentioned along with the harassment discrimination policy, but it's always good to have a standalone policy or even a separate section on workplace violence, weapons, that sort of thing. Electronic communications, if you're in the workplace or industry where your employees have access to phones, cell phones, email, that sort of thing, you may want to limit how those are used, right? Even just internet access, do you want your employees to be able to browse any kind of website and download any kind of material, or do you want to limit that? That's where this comes into play, right? Non-solicitation policies, very important for hoping to keep a hand on the flow of information, basically, or what information makes into your job site. Dating in the workplace, again, this is going to vary by industry, by company, by person. So make sure you know what works for your company. Some places don't want supervisors and their direct reports engaging in any kind of romantic relationship. You can limit that. Now, if it's coworkers, not so much, right? California Constitution may step in and say, well, people have a right to privacy, people have a right to live their lives. But as far as any kind of supervisor and reporting, being engaged in a romantic relationship or any other relationship for that matter, family relationship, you can limit that because it could be detrimental to the business. So if you plan on doing that, make sure that that's defined in your handbook as well. And then finally, outside employment, you could put something in your handbook saying that outside employment is okay, but we want you to focus your, most of your attention to our job site or to our job or what have you. So that is all, things that you can and probably should have in your handbook. I'll dive a little bit deeper into drug-free and workplace policies, right? And that's, I mean, it's an issue that it varies obviously by industry, it varies by job, varies by duties and everything. So it's important to talk about now. One thing that CAC as a whole is we recommend having a drug-free or workplace policy for all employers, no matter what your industry, right? And if you are going to put that in place, is you want to inform your employees before you can test them now. Some of you, if you have employees that are bound by any DOT regulations, you know that you could do that random testing. You have to put in the pool program, so on and so forth. If not, though, if it's just a regular, or what I call a regular workplace, it is very risky to have a random drug test policy in place. And if you're really serious about doing that, we recommend you talk to legal counsel for that. However, you can do reasonable suspicion testing. And what that basically is if you're going to put your managers, supervisors through a short training, basically help them identify some of the telltale signs of being under the influence, right? Once they go through this training, you write out a policy that basically states that if there's reasonable suspicion to believe an employee is under the influence of any kind of drug or alcohol or what have you, that you can request for them to be tested. If they refuse to test, there's these steps, so on and so forth. But make sure, obviously, don't just throw it in there in your handbook willy-nilly. Make sure you do your homework on it. Make sure you know what training you're going to put your supervisors through. Make sure you know who's going to be able to make that assessment as to whether a reasonable suspicion is necessary, right? Things to keep in mind, I mean, lately we know, and we'll talk a little bit more about the marijuana legalization and usage in the state of California or throughout the country for that matter. But the thing to keep in mind is that there's no law that precludes disciplinary action against employees under the influence of drugs or alcohol at work. So alcohol is legal in the state of California in the United States. Just because it's legal and people can do it at home does not mean that you have to allow it to be used at your workplace. Think if you're in the workplace that has heavy machinery, or in the medical field where you're in charge of other people, or school bus drivers, that sort of thing, right? I mean, there's nothing in the law that says just because it's legal, you have to allow it in your workplace. So another question that comes up is, well, we've heard that, drug abuse, alcoholism, it's a disability, it's protected, so on and so forth, so we can't do anything about it. Well, not always the case, right? I mean, there are substance abuse protections under the Americans with Disability Act and the Fair Employment and Housing Act and the Labor Code. However, that doesn't necessarily extend to on-the-job protections, right? So what that means is that, that is not basically a silver bullet defense for somebody that's caught being under the influence at work. If you have an employee that's never talked to you about having an issue before, never said anything about it, never told you they're seeking treatment or whatever, and you catch them, trying to do something very risky, that's putting your company, putting your coworkers, putting the public at harm, I mean, you need to be able to manage that and handle that to protect your company, to protect your employees, and to protect the general public. Okay. When it comes to the use of marijuana, I mean, seems we can't drive anywhere nowadays without seeing a dispensary advertised on the billboard anywhere. So it's here, right? I mean, there's almost 20 states out there with legalized marijuana, and more just keep joining, and this was one where California actually wasn't the first to do it, right? We had Colorado, Washington, Alaska, Washington, DC, and then California jumped in to legalize marijuana for adults, right? And basically what this is, it allows the recreational use for any adults the age 21 and over. But the important thing to keep in mind is that this doesn't really have an impact on drug-free workplace policies. Just because it's legal doesn't mean it's be allowed in the workplace, right? And what thing we always say is treat marijuana use the same as alcohol, just because someone can go home and have, a drink or two or 7 or 10 doesn't mean that you should allow them to do that at the workplace. I mean, it's very simple. You still have to provide a safe workplace for all your employees. So the other question or the thing that came up early on when marijuana was starting to pick up steam, so to speak, in California was the medical marijuana cards, right? And these were, for a long time, these were the hot tickets. It went from, used to be getting a fake ID growing up was a thing to do, and all of a sudden getting that medical marijuana card was a thing to do. Well, there's At this time, I should preempt to say, but at this time, there's no requirement for accommodation for medical marijuana. So just because somebody says, hey, I'm going to apply for a job and, it's okay for me to use because I have a card, well, not really, because right now the law doesn't say you have to accommodate that. I say right now because there's been some movement on it, especially in some other states, about not taking any kind of action against people that use medical marijuana and maybe under the influence in the workplace. So keep an eye on that, but for the time being, that is not the case. Thing to remember about marijuana is still considered a Schedule I narcotic under federal law, alongside heroin, meth, cocaine, that sort of thing. And so that's what allows employers to still limit the use of it in the workplace. Okay. Now, when it comes to discipline and how you address it in your handbook, one thing that we recommend, and Astrid touched on this as well, is you want to present discipline as a guideline rather than required set of steps, right? So you don't want discipline to be like a punch card, strike one, okay, strike two, okay, you get 4 strikes and we can't touch you until we hit that. Well, no, you want to have the ability to handle things on a case-by-case basis, based on severity, based on, any other factors, right? You want to be able to weigh all of that. If you just say, all employees will get 3 strikes before they get a write-up, I mean, what are those 3 strikes? How severe are they? Is someone showing up late going to be weighed the same way as, or do they have to be weighed the same way as someone that wrecks into the side of the building or what have you, right? So that's why it's important not to really tie yourself to that progressive discipline as much. When it comes to discipline policy, you want to reiterate that you are an at-will employer, and disciplinary action does not alter that at-will status no matter what. And some of the language we suggest using is, a violation of any company policy, either written or otherwise, may result in disciplinary action up to and including termination. That gives you as an employer the option to address each circumstance on a case-by-case basis without, like I said, without being tied, without having to be limited to what you can do, especially for a very severe violation of policy. Some other suggestions for your handbook: company social media accounts, right? If you have an employee that has access to them, you're going to want to limit what's posted on there. You also can put something in there about how employees portraying themselves as representatives of the company as well, right? If you're a company that issues uniforms, that sort of thing, I mean, social media is out there, it's everywhere. You don't want your employees basically being seen as the face of your company at all times, right? During work hours, when they're doing everything you want, that's great. During after hours, maybe not so much. So that's something you want to address on there. The use of mobile phones, right? Everybody's got a cell phone. It went from everybody, having a pager to a few people having a cell phone. So now it seems like everybody's got a cell phone. How do you want to treat that in the workplace? Do you want to limit people to having it on them at all times? You want to say they can use it at breaks? Do you want to keep them off the work floor? Your handbook's going to be where you're going to put that in there. Breaks, meal periods, after hours work, working after the clock, working off the clock, that sort of thing. You're going to want to put something in there about it, especially if you have hourly employees that are given cell phones or that, possibly are contacted after hours. You want to make sure that you define what is to be done for that, right? Remember, just because they clock out doesn't mean that the hours aren't compensable. If your hourly employee clocks out and you call them up and keep them on the phone for an hour asking them questions, they're owed for that hour. So make sure you have something in your handbook about that. Company vehicles and gas cards, make sure you have something in your handbook about that. If you issue company vehicles or cards, what are they limited to? What's the use? Can anybody use them? Can they take them home? That sort of thing. Make sure that is all outlined in there. Injury reporting. I mean, a lot of our members, and even when some of us were out in the field as HR managers, how frustrating is it when you hear about an injury that happened 2 months ago, but it was never reported, and you go back and turns out there wasn't a policy about reporting it, or maybe there was and it was ignored or not enforced or anything. Make sure that your injury reporting procedure and guidelines are in your handbook, signed for, and that you're consistently enforcing or following those as well. Company property, that comes if our employees allowed to take company property home, can they use it for personal use, that sort of thing. as well as personal vehicle use. If you have a restaurant that does deliveries or anything, what are your requirements? Do you require people to have insurance, a valid driver's license? When do they have to notify you if their status changes, that sort of thing? Make sure that's spelled out as well. Okay. Things not to include in your handbook, Astrid touched on this, those probationary periods, right? Reason why, if you say, there's a 60-day, 90-day, whatever probationary period, that starts kind of blurring that at-will relationship a little bit, because what do you have to overlook during those 60 days or 90 days or whatever? Can you really enforce all your rules that time? Just because you can say, well, I'm going to fire him because I'm under probation, they can also say, well, you can't fire me because I made a mistake, I'm under probation, what do you expect? So we recommend not to put anything about probationary periods in your handbook. I mentioned the lockstep disciplinary procedures. That's where you're tied to doing the strike 1, strike 2, strike 3, or you have to follow specific steps. You want to be able to have a little room to a little wiggle room there to address situations as they come up and address all the factors for them. Policies that are subject to frequent change. If things change all the time, you don't want to be updating your handbook 2, 3, 4 times a year. It's difficult enough trying to update it once a year when the state changes laws. It is not something that you want to change all the time, because one, it's going to frustrate employees because you're going to be changing on a frequent basis. It's going to make it hard to enforce things, hard to keep everybody trained up on it. So just if you have policies that change all the time, maybe those need to be standalone outside of the handbook, right? Any policies that imply job security or contractual obligations, again, anything that changes the at-will nature of work, you want to keep those outside of your handbook. Otherwise, they apply or could apply to everybody. Any supervisor or manager information that goes very in-depth, that should be part of your policies and procedures manual or standard operating procedures or the job description. No need to put that in the handbook. It's just going to muddy things up. So leave those out of there. Details of benefit plans. I mentioned we touched on these a little bit. You can put something in there saying when employees are eligible for benefits and what employees are eligible for benefits. For example, if employee works 30 hours or more a week, and after their 90th day, they're eligible to participate in our company health plan. That's fine. But then if you're starting to put stuff in there about deductibles, about costs, so on and so forth, as anybody that's worked with benefits knows, these things can change every year, right? And they should. You want to go out there, you want to shop around, you want to make sure you're getting the best value for your dollar and the best benefits for your employees. So if it's changing all the time, you probably want to leave those out of there. Finally, pre-employment practices, talking about pre-employment drug screens, background checks, interviews, that sort of thing. No need to put them in the handbook, right? That handbook's for your current employees. Pre-employment, you can put that in the offer letter, you can put that in the application. There's other places to put that. No need to put them in your handbook. One thing we recommend for a lot of our members and anyone that calls to consider is an employee action hotline. And this just goes along with that open door policy, right? Basically it reduces liability. It gives employees another avenue to report any issues, right? Sometimes, even if it's not true, they may perceive that they can communicate to their supervisor, their manager, management, ownership, whatever, because of a perceived relationship, perceived preference, what have you. So if you have that employee action hotline, it really allows them to be able to express themselves, gives them a little peace of mind knowing, hey, there's a way for me to deal with these issues, a way for me to address them without feeling that I'm going to get in trouble or I'm going to get somebody in trouble or having to directly walk in there and do it, right? It's a good deterrent for sexual harassment. And really, it allows you as an employer gives you another way to see what's going on in the workplace, right? We'd like to think that our employees are always open to us and that they're always going to share their concerns with us. Unfortunately, that's not always the case. That's just reality. Some people just aren't comfortable doing that. So having that employee action hotline, anonymous reporting, that's going to help you, become aware of some of those issues that otherwise you might not, and really help reduce your liability down the road. So, you're always going to want to check your handbook for those required leaves and that leaves of absence policies that Astrid talked about. Reasonable suspicion or post-accident drug testing policies, make sure that if you do that, those are in there. Rest period and meal breaks, harassment policy requirements. That should be right at the front of your handbook, under the non-discrimination policy, right? Gender specific references, make sure that your handbook is gender neutral. He, she, they, make sure it is gender neutral. That's all I'm gonna say about that. FEHA is a gender neutral, so they're gonna enforce that and make sure that you go through your handbook and make sure that's the case. Any language that violates the National Labor Relations Act, right? Anything that says, you can't talk about your condition, or you can't talk about your work conditions or about your wages with your coworkers, that sort of thing. That could be a violation of the National Labor Relations Act. Make sure you're very careful with that. And things change all the time. If you haven't changed your handbook in a couple of years, it's out of date. Even if you have, like, for example, CFRA policy, there's been changes the past 2 years. There was a change on January 1st, 2021, changes on January 1st, 2022. Specific things that had to be added on there to stay up to date. So if you haven't updated in over a year, chances are you're out of date. So go, dust that thing off and take a look at it. Okay. Other things, you should review it, distribute it to your employees, get those acknowledgements back, right? You distribute it on the first day when somebody starts, make sure you distribute it when there's any changes and you get the acknowledgements back, put them on file. That's going to help you down the road if there's ever any issues as far as having to enforce any disciplinary action. Make sure you monitor it, see if it's effective, right? Just because you put a handbook out there, make sure it's being followed, make sure it's meeting the employee's needs, meeting your needs, get some feedback on it, and train those managers for consistency. Your managers are that first line of defense out there. They're the ones that are enforcing this, that are responding to those issues, first of all. And unfortunately, in many cases, they may be the ones that are going to get you in trouble. So make sure that they're trained, they understand, and that they're confident enough to know, hey, if I don't understand, I'm going to go to management and get that answer before I give that wrong answer. On top of the handbook, make sure you're updating your labor law posters every year. Injury and illness prevention program, keep that thing updated. If any of you have had OSHA visits or anything, that's one of the first things they ask for. And if you pull out your IEPP and there's an inch of dust on it and you have a bunch of names of people that don't work there anymore, things aren't looking good. Your COVID prevention plan, new requirements since COVID hit us, make sure that's up to date, make sure it's up to date with all the changes. And we recommend you keep that separate from your IEPP and your handbook. We also recommend you keep your injury and illness prevention program out of your handbook as well. Reason for that is if you have a state agency that comes in and asks for one specific document, you're not handing them a stack of papers to leaf through. Now, if they ask for your IEPP, that's all you're giving them. If they ask for your COVID prevention plan, that's all you're giving them. Helps prevent problems down the road. At least that's what we've found. So with that, brings me to the end here. Do we have any questions floating around out there or anything?
I think we covered them all, Eli. Thank you for that.
Sure. I saw you shutting some of those. Yep. Going through some of those, they came up. So with that, let me turn it back over to Jerry for some closing here.
Well, first of all, I want to thank Estrid, Eli, both of you. You did a very comprehensive job in giving us that overview. The reason I wanted to say thank you and is to encourage you to keep in touch with us. You can reach me, Jerry Hernandez, at 755-5393, 755-5393. We can set up a Zoom call. I can go over the services we offer online with you and go over the requirements individually. So I just wanted to, again, thank you for being here this afternoon. And I'll hand it over now to Tara to close out the program.
Great, thank you so much, Jerry. I'm just putting the continuing education codes in the chat box, and it's also up on your screen. So the HRCI code is 579110, and the SHRM code is 22-Q, Q7NWK. Be sure to put the dash in between the 22 and the Q. And then I was also just going to put in the Monterey Business Hotline that you all have access to as well. I believe we showed that screen way early. So let me just throw that into the chat box as well. So you have that. And like Jerry said, you can contact him as well. So thank you everybody for all of your participation. It was great having all the questions. Thank you to Eli and Astrid for all of your great info and wisdom. And Jerry, as always, it's a pleasure to work with you and the Monterey Workforce Development Board. So thank you so much. Everyone have a great 3-day beautiful weekend, and we'll take good care. Thanks, everybody. Bye-bye.